Thank you very much. My name is Toby Cadman. I'm a lawyer from the United Kingdom, and I represent Naqib's father, but I also represent the leadership of the Jamaat Islami political party, who are currently facing trial. First of all, I'd like to say that it really is an honour to be able to address the media on a very important day for Bangladesh. I would have liked to have made this address in Bangladesh. I feel as though it would have been an important day for Bangladesh on its 41st anniversary, but also on the second anniversary of the establishment of the International Crimes Tribunal. Unfortunately, I'm not allowed into Bangladesh. I was thrown out of Bangladesh in August of last year. It was the 6th time that I was to visit Bangladesh. I was refused entrance, refused a visa by order of the Home Minister. I was held at the airport for 10 hours, and then I was unceremoniously thrown out of the country. There have been a number of allegations raised against me for attempting to unlawfully enter the country, all of which are false, and all of which are completely unsubstantiated. What I would like to say today, I'm not a politician, I'm not a political activist, but I am a lawyer. And my role in this is purely as a lawyer. I'm an international criminal lawyer, and I specialise in war crimes and human rights law. That's what I've done for the last 10 years. And because I do that, I believe that a process has to accord to certain fundamental standards. I've always made the point that the International Crimes Tribunal in Bangladesh is something which is an obligation. It's not something that shouldn't be done. It's something that should have been done 40 years ago. It's unfortunate that it's taken so long, but it shouldn't be criticised and shut down now purely because we don't agree with the way in which it's being done. But it means that it has to uphold certain standards, and it's not. Now, the establishment of the International Crimes Tribunal was a core electoral pledge by the Awami League government to bring an end to impunity. Now, these words mean a great deal. Bringing an end to a culture of impunity is an international obligation on any state. If crimes have been committed on their territory, they are required to bring justice to the victims. They largely secured the election on the strength of this pledge. And ever since that time, they have given a number of representations to the international community and to the people of Bangladesh that this process will meet the highest international standards. It does not, in my opinion. Just this weekend, the Prime Minister has once again said that this process is strictly in accordance with domestic law and strictly in accordance with international standards. And I have been criticised for mounting an international conspiracy for saying that it doesn't. Well, I'm not the only person who's criticised this process. The United States Ambassador at Large for War Crimes, Stephen Rapp, he has also expressed concern. Amnesty International, Human Rights Watch, International Centre for Transitional Justice, the International Bar Association, members of the House of Lords in the United Kingdom, members of Congress, members of Senate, have all expressed reservations. So if I'm at the head of an international conspiracy, then these are my co-conspirators. And the conspiracy is to ensure that our clients, Naqib's father, and the other defendants receive a fair trial according to international standards. I would hope that that's not asking too much. One of the areas of concern has been the status of this tribunal. Is it an international tribunal or is it a domestic tribunal? Because if it's international, it is required to adhere to international law, and ordinarily it would be created by international agreement. I agree with the government in this regard that it's not an international tribunal, so we should stop referring to it as such. It is a tribunal that tries individuals of crimes penalised under international law. but that doesn't mean it's international. There have been requests, offers of assistance for this to be an internationalized process. And my personal view, with 10 years of experience of dealing with cases of this kind, it should have been an international process. There should have been greater international support, and Bangladesh should have accepted that support so that there are independent and impartial international judges and prosecutors and defense counsel that participate in this process. In 2009, we are led to believe that the United Nations offered this to Bangladesh, but that was refused because this is considered to be a domestic problem that will be dealt with domestically. That, in my view, is a mistake. Justice must not only be done, it must be seen to be done. The real perpetrators of these crimes, and let's not forget the fact that a large number of people suffered during a very brutal conflict in 1971. I'm not here to suggest that people didn't suffer. People suffered at a level not seen in that part of the world over a very long time. It could be considered one of the worst conflicts of its kind in modern history. Now, there have been numbers as low as 300,000 and as high as 3 million. It's not for me to suggest how many people died, but that means that process has to be properly adjudicated. So, if it's not an international tribunal, is it a domestic court? In my view, no, it's not a domestic court either. It was established by an Act of Parliament. It doesn't make it a domestic tribunal because it excludes basic principles of domestic law. It excludes the Criminal Evidence Act and the Criminal Procedure Act. There is a first constitutional amendment that excludes fundamental universal rights. There is no right to challenge any decision of the tribunal. There is no right to challenge the appointment of an individual judge. And there is no right to bring any form of interlocutory appeal or judicial review to the High Court Division of the Supreme Court. Those matters in themselves indicates that it's not a domestic court. So if it's not an international tribunal and it's not a domestic court, how can we characterize it? Well, in my view, it's an extraordinary tribunal that sits outside of the law because there is these fundamental restrictions placed upon it. And in my view, Bangladesh is missing a very, very important opportunity to bring an end to impunity, and that is essential. I've always said, from the first moment that I addressed anyone on the subject of the International Crimes Tribunal, that this process had to address the victims of 1971. It would be preferable that there was a tribunal that could sit in judgment of all of those who committed crimes in 1971, irrespective of whether they are from India, Pakistan, or Bangladesh, in an international setting. This tribunal was initially conceived in 1973. A number of experts with the International Commission of Jurists at that time made a number of recommendations for how this process should be established. And there were recommendations that this should be an international process in 1973. It was established primarily to deal with a particular situation, and that was primarily a number of Pakistani prisoners of war. There were restrictions placed on the right to challenge the jurisdiction of the tribunal for very important reasons at that time. I don't necessarily agree with them, but I can understand in a developing nation in 1973 why those restrictions were placed in a military tribunal setting. But it has no application for a civilian court in the modern day. We have gone far past the principles of Nuremberg. It is not sufficient to say there's a right of appeal against conviction and sentence, thereby the proceedings are fairer than Nuremberg. We have advanced significantly past Nuremberg, and there are principles, fair trial, universal standards that we need to apply now. These are all capital cases. These are all members of the political opposition. This process has to be beyond reproach. It has to address all of those accused of crimes. It has to enable those accused of crimes the right to properly contest these allegations. If this process, in my view, and it is only my view, if this proceeds in this way, then the victims will see no justice. And for that reason, we have made a number of recommendations, and not just myself, many members of the international community have made recommendations for the process to be improved, to be updated, in accordance with, in particular, the recommendations made by US War Crimes Ambassador Stephen Rapp. Those recommendations have not been implemented. We call again on the government of Bangladesh to make those recommendations, to implement those changes, in order to show that these trials will be fair. Because it will not serve Bangladesh unless these trials are fair. Again, nobody is trying to minimize the suffering of the people of Bangladesh from 1971, and nobody is trying to criticize Bangladesh as a government for establishing this process. As I said at the outset, it is required to do so under international law, but it is also required to do so according to certain standards. Thank you.
Could I ask, before you said I could ask you one question?
Sure.
You said it cannot be called the International Tribunal or a domestic, and you said it could be called an extraordinary tribunal. We were talking about the Cambodian situation. Would you compare it to that?
Well, it's actually quite quite different, actually, because the Cambodia tribunal is more of what we would call a hybrid tribunal.
It's two parties, right?
Yes, it's by agreement. Now, ordinarily what you would have, and my experience primarily comes from Bosnia, where we had a internationalized tribunal in a domestic criminal justice system, which was quite different to Cambodia. Cambodia was set up by international agreement. But Bosnia was also by agreement, but it was considered to be a national court with international assistance, whereas Cambodia is an international ad hoc tribunal. So there are certain differences. My recommendation was always from the outset that it should be more of an international supported process in Bangladesh. It would give it much more credibility. It would ensure that certain standards were complied with. That would require, of course, amending the legislative framework. It would also require amending, for example, one of the main points that we've asked to be amended is the 1st and 15th constitutional amendments. I do not see how any just process, and for those of you that are not aware, the 1st and 15th Constitutional Amendment restricts fundamental constitutional protections of due process. They do not apply to anyone accused under this Act. I can see no legitimate basis for doing that. The reference that I made to the tribunal being established in 1973, because that was to deal with matters in a military setting, there may have been justification for doing that. But there is certainly no justification for doing that with a domestic court within the ordinary domestic system.
Thank you very much. We're open for questions now. Please, like I say, turn off your cell phones. First one to send. Please give your name and affiliation when you ask your question. Who's first? Who's second? Yes, sir. Yes, sir.
Yes. My name is Rashid Ahmed. I'm from HRDB. And my question is, are you saying that you cannot defend your client because the government are not allowing you to enter Bangladesh?
It's slightly more complicated than that. The rules as they are drafted allow for foreign counsel to appear. And that hasn't been amended in the last round of amendments that were made in May of last year. So that rule still exists. But it exists by the condition that the Bar Council gives consent for a foreign counsel to appear. which is entirely understandable, because the Bar Council is the regulatory authority that gives the permission for a foreign counsel to appear. The point that we have tried to express, and I can say in a discussion that I had with Ambassador Rapp, the Law Minister, and 2 of the judges and the Registrar of the Tribunal in May of last year, before the amendments, I had proposed implementing a process very similar to what the Bosnian court did, which was to give that power, allowing foreign counsel to appear, to the tribunal, that they would set certain standards, that those foreign lawyers had to be experienced in war crimes and they had to have a certain level of experience. And so the point was, we were not seeking to be admitted as advocates of Bangladesh, because we cannot be, because we're not citizens of Bangladesh. We were requesting to be permitted to appear before the tribunal, a specialist tribunal that deals only with war crimes cases and not before any other court. The Bar Council refused that permission, refused to give consent, but they made that decision purely on the basis of citizenship. My view is that that was wrong. So how does that affect our relationship now in representing these individuals? That means we have to work very, very closely with the Bangladesh Council. We've had to work with them in terms of providing training in this very specialist area of law and assisting them, if need be, on a daily basis by communicating with them and ensuring that they are prepared for trial. Because these are very, very difficult types of trials. The 3 British lawyers, myself included, have a minimum of 10 years' experience each in doing these types of trials. Stephen Kay QC is probably one of the leaders of this area, having done the first Yugoslav tribunal, the first Rwandan tribunal, and has represented heads of state. John Kamei acted in the longest-running trial in Sierra Leone. My experience comes from prosecution. I spent many years in Bosnia coordinating prosecution, running trials, assisting in the prosecution of genocide in Srebrenica, and working with the International Tribunal, Criminal Tribunal for the former Yugoslavia. So we were requesting that we be permitted to appear before the tribunal on the basis of our collective experience. That process was denied. It is further complicated by the fact that I'm not permitted to enter Bangladesh. My 2 colleagues have requested visas to enter Bangladesh, which they requested in December, that have not been responded to. So not only are we not permitted to enter the courtroom, we are not, on a de facto level, entitled to enter Bangladesh at all.
Mr. Rahman, did you want to add anything to that?
No, if you have any questions, I'll be glad to answer.
All right. Next question. Anybody? Yes, sir.
My name is Jamaluddin. I'm from Virginia. Why are the trial not taking place at the International Criminal Court?
The International Criminal Court in The Hague. The International Criminal Court in The Hague has very, very specific jurisdiction to deal with. The International Criminal Court in The Hague has particular jurisdiction to deal with war crimes cases. Bangladesh is a state party to that, but it is only a state party since 2010. That means if, God forbid, there was a conflict in Bangladesh now, those matters would fall under the jurisdiction of the International Criminal Court. But the International Criminal Court has no retrospective jurisdiction. What we have tried to do in speaking to the International Criminal Court is to almost push them into a debate with the government of Bangladesh to provide assistance. But they're very reluctant to do so because of their jurisdictional barriers. So they only have jurisdiction for matters, as far as Bangladesh is concerned, from 2010 onwards. Much in the same way that you see other conflicts that have occurred many, many years ago, the International Criminal Court doesn't have the jurisdiction and doesn't have the capacity to deal with it. That's why we've always advocated for the establishment of a special tribunal, an ad hoc tribunal, that is created by international agreement between the United Nations and the government of Bangladesh. But as I said earlier, unfortunately, Bangladesh has taken the position that this should be dealt with domestically. Now, I can understand the reasons for doing that. Having spent many years in Bosnia, I can see why there is a desire to bring justice to victims in the region where the crimes occurred, but not at the risk of flouting international obligations of ensuring fair trials, and not at the risk of putting victims and witnesses at risk where there is no adequate witness protection mechanisms. So there are many reasons why there should be an internationalized process, but unfortunately, it's not a matter that the International Criminal Court can take on board. The reason why Bosnia had a system of having more judges, first of all, there was international money. So unfortunately, matters like this ordinarily will boil down to a matter of finances. The Bosnian tribunal cost an estimated €5 million per year to run. But then we dealt with 200 or 300 cases, whereas Bangladesh is looking at a smaller number of cases. But the reason why it's important to have more judges is that there are different stages in the proceedings that should be dealt with by different judges. For example, a preliminary matter such as bail will often involve a consideration of the merits of the case. So if a judge at the early stages has ventured into an opinion on the merits of the case when considering bail, he can't possibly be considered impartial when it comes to deliberating on the facts of the case at trial. And he certainly cannot sit on an appeal. So the reason we had those judges in Bosnia is that there would be a preliminary hearings judge who would deal with the first matters. There would be a panel of 3 judges who would deal with the trial. There would be a panel of 3 judges that dealt with the appeal. The situation that we have in Bangladesh is that the panel of 3 judges deal with all preliminary matters that involve an assessment of the merits of the case. They deal with the trial, and because there's no right of interlocutory appeal, there is only a right of review. The judges are required to review their own decisions. So under basic human rights law, this is incompatible with having a fair trial. As to the second question of the establishment of a second tribunal, I won't use my own words. I'll use the words of the ministers who have commented over the last 7 days. The new panel of judges, or the new tribunal as it's being called, is being set up to accelerate proceedings, not to provide the first tribunal with assistance, not in order to ensure the protection of fundamental rights, but to speed up or to accelerate the process. One of the concerns is that as a result of this new tribunal, one of the judges in the Saidi case has now left the trial to become the chairman of the second tribunal. That means that a new judge has now joined the panel of judges in the Saidi case. The Saidi case is near the prosecution case. This judge has heard none of the evidence. He hasn't been sitting in court listening. There is no transcript of the proceedings. There's no record of the proceedings. So how is he possibly going to be able to render a fair judgment having heard none of the evidence? And there is another matter that I must say in relation to the Saudi case, which is of great concern. The prosecution, as many of you will know, were required to file a list of 68 witnesses that they intended to call. They have called less than half of those witnesses. They now intend to, or they have applied to the tribunal to serve the remaining witnesses in statement form only. That means that the defence would have no effective opportunity to cross-examine these witnesses and to challenge their credibility. And that is, of course, a serious concern. Now, I don't want to comment on that further because it is a matter that the tribunal, and we have responded to it, that the tribunal has yet to rule on. But it is a matter of some concern. One, it's not for me to say whether this is a politicized process or not. The court will have to make its own determinations of the evidence. what I would like to see is that justice is not only done, it is seen to be done. That the politicization of this is removed, and that the procedures, the legislative framework is set up to enable judges to try these matters according to law, according to fundamental principles, not according to politics. That means that ministers have to stop commenting on the guilt of these individuals. They have to stop using sensationalist language that they have been repeatedly using. They have to enable a fair process that targets all perpetrators of 1971. That means that Presidential Order number 16 of 1973, that gives immunity to one side of the conflict, has to be repealed in order for this process to be fair. The First and 15th Constitutional Amendment, insofar as it relates to these trials, has to be repealed so that these individuals can be entitled to a fair trial. Only then will it be impossible for somebody like me or any supporter or any proponent of this, this process to say that this is politicized or not. If you remove all of those barriers, it will be impossible for me to make any comment. And that's what I would ask the government to do. And I know we're running out of time, but the final thing that I would like to say is that I attended a conference this weekend in Stamford, and this was the United National Anti-War Coalition National Peace Conference. And I expressed the same concerns that I've expressed today, and they adopted a resolution that they would like to communicate to the government of Bangladesh. And I would just like to read that out very, very briefly. The Bangladeshi government, working closely with the United States government and American corporations, has embarked on a policy of stifling this in Bangladesh. We therefore demand to the government of Bangladesh, first, to repeal the First and 15th Constitutional Amendments insofar as they relate to the International Crimes Tribunal. 2, repeal Presidential Order number 16 of 1973. 3, implement fully and without further delay the recommendations of United States Ambassador at Large for War Crimes, Stephen J. Rapp. 4, implement fully and without further delay the recommendations of the United Nations Working Group on Arbitrary Detention. 5, amend the International Crimes Tribunal Act 1973 to bring it in compliance with the International Covenant on Civil and Political Rights. And finally, issue a decision allowing international trial monitors and foreign counsel to participate in proceedings before the tribunal. That resolution will be communicated to the government of Bangladesh. I sincerely hope that the government starts to take this seriously because of all the recommendations that have been made and all the concerns that have been expressed. To date, nothing has been done. Thank you.
Raman, any comments?
Like as I said, I'm not a lawyer, so I wanted to avoid all the legal questions. Just to add one small little note here. Basically, the accused will always try to argue on that point that, of course, its government is vindictive. So it is the job of the government to make sure that no such questions arise. But what government is doing is basically keeping on harassing the relatives and the supporters of the accusers. And they even went as far as basically coming up with a law in the parliament banning any sorts of activity surrounding defending the so-called war criminals. So clearly government is politicizing that, and it is you can simply see that how they're basically victimizing, trying to eliminate their political opponent. Thank you.
One more question. Yes, sir.
Yes, it is very, very difficult for me to stand up here and not say it's a politicized process, because everything that I see really speaks of a political process. You know, there have been comments used such as a witch hunt, a political witch hunt. I think I've used the term a wolf in sheep's clothing, which is how I've expressed this. So it is very difficult for me to stand up here and say it's not a political process. But as a lawyer, it's inappropriate for me to say that this is purely politicized. And I hope that from what I say, there will be changes to ensure that it doesn't continue as a political process. But yes, it is the political opposition that is being targeted. It is one side to the conflict that is being targeted. There is no independent selection of targets, of defendants. It is important to note that the tribunal was established in March 2010, and about 4 months later, the first arrests were made. Now, I would say those are probably the promptest investigations in war crimes history. So there is scope for suggesting that it is a political process. Insofar as why are they all being held in custody, well, there have been remarks made, there has been pressure brought to bear by the government by saying that these individuals are responsible for all crimes committed during 1971, which in my mind is ludicrous. But there is significant pressure on the judges when they're making determinations of bail. And you've only got to read the decision of the United Nations Working Group on Arbitrary Detention to show that the custody of these individuals is arbitrary and in breach of international law. I also consider that the conditions under which these individuals are being detained is also in breach of international law. I have raised that with separate working groups, the United Nations and the Special Rapporteur on Torture. We have also filed more recently a petition with the United Nations Working Group on the independence of judges, because there is also that concern that one of the, I believe somebody earlier spoke about judges assisting the prosecution. That is a current theme to these trials, and it is of concern. There is also the question that one judge in particular had participated in the People's Inquiries Commission. That is also of concern. So those matters have been brought to the attention of the United Nations. I, for one, as I'm a lawyer, hope that the United Nations acts promptly and raises these issues in a very practical way with the government of Bangladesh, and that some resolution is brought to this.
Paul, no, I'm sorry. Would you like to say anything?
Basically, just closing. As I said, I've already closed my remark. Now, the question might come as like, how do you go about it? So, my simple and humble request to all of you is that let the truth be heard. We're not afraid of truth, but truth needs to be heard. Right now, the sufferings that people are having in Bangladesh, nobody is making a buzz out of it. So we need to hear. We need to be heard. Thank you.